Hello and welcome to this YouTube video. I'll be presenting on the introduction to the module of jurisprudence as assigned by my lecturer, Mr. Ngosana Maphosa. My name is Nkosi. I'm a 3-2 student at Herbert Chitepo Law School, and I have been assigned to give a brief introduction of the meaning of jurisprudence, its history, and the perspectives in jurisprudence, and how one approaches jurisprudence. So basically, jurisprudence is the study of law. The law, the concepts, principles, methods, and its related theories as an academic discipline. So jurisprudence is concerned with the nature of the legal system. Which legal system are we dealing with? We look at the nature of the legal system. So I'll be mapping the jurisprudential terrain to first define the meaning of jurisprudence as given by various scholars, and then give the perspectives of jurisprudence. But before I delve into the perspectives, I'll first deal with the history of jurisprudence, and then I'll set out a brief synopsis of the case of the Spelunkian explorers. And I have justified that I have taken this case of the Spelunkian explorers to give a brief overview of the case, because the case itself, if you read the case, you will get a brief overview of what jurisprudence is all about, how judges think in terms of the jurisprudential thought of view, how the individuals or even lawyers look at the law from different perspectives. So I will start by defining what is meant by jurisprudence. So one of the scholars, that is W.J. Harris or J.W. Harris, in his book Legal Philosophies, defines jurisprudence. He states that jurisprudence is a rag bag. Into it are cast all kind of general speculations about the law. And one of the other scholars, that is R. Posner, The Problems of Jurisprudence, in his book The Problems of Jurisprudence, he states that jurisprudence addresses the law questions that an intelligent layperson or speculative bent, not a lawyer, might think particularly interesting. What is law? Where does the law come from? Is the law an autonomous discipline? What is the purpose of the law? Is the law a science, a humanity, or neither? A practicing lawyer or a judge is part to think questions of this sort, at best irrelevant to what he does, at worst naive, impractical, even childlike. How high is up? So basically, this is what R. Posner was saying in his book, The Problems of Jurisprudence, defining that the jurisprudence wishes to addresses the terms in which an intelligent lay person would think are very speculative, important, but the judges themselves or lawyers cannot think these questions are not important. Like asking what is law? Where does the law come from? Is it an autonomous discipline? Is it automatic? Does it operate from a vacuum or not? What is the purpose of the law? Is the law a science, a humanity, or neither? In which a practicing lawyer or a judge can never think about. Generally, the quotations above introduce one not only to the array of jurisprudential thought, but also a framework within which situate and evaluate the various theories that one is going to encounter in the field of jurisprudence. Many of the theories neither sit next to each other without any clear connection, or are set against each other in debates or in rival for the true concept of law. How does the law function, and where does the law come from, and what purpose does the law wish to serve? The term jurisprudence is derived from the Latin words, that is juris prudentia, meaning knowledge or wisdom of the law. Broadly and ambitiously speaking, this is what it is all about. This is what I am going to be discussing about. Giving an overview of the knowledge of the law, it seeks to introduce one to the critical concepts about the nature and the functioning of the law to develop in the student an analytical, broadened, and searching legal mind, as my lecturer, Mr. Maphosa, would set out or articulate it. After defining the term jurisprudence, I will now move on to the history of jurisprudence. So I have defined the meaning of jurisprudence, the two Latin words jurisprudentia. I will now delve into the history of jurisprudence. So the whole history of what I am going to be talking about was extracted from Nicola Lyce, Jurisprudence, History, and the Institutional Quality of Law, that is Virginia Law Review, Volume 101, number 4. That is where I extracted the whole concept of the history of jurisprudence. So I shall then start. The history of jurisprudence dates back to the ancient Greece and Rome. The Greek philosopher Aristotle was one of the first to develop a systematic approach to the study of law. His work focused on the nature of the law, its sources, and the relationship between law and morality. He argued that law should be based on reason and the common good rather than the arbitrary rules, the will of the state, or the will of the state. In Rome, the term jurisprudence was first used to refer to the study of law in the 2nd century BC. The Roman jurist Gaius, the popular Roman jurist Gaius, classified law into 4 categories: natural law, civil law, the law of nations, and customary law. Roman law had significant influence on the development of legal systems in Europe, specifically in the Middle Ages. In the Middle Ages, the study of law was dominated by the canon law of the Catholic Church, that is, where the orthodox approaches, like, for example, the orthodox approach to legal personhood was then developed. The church's legal system, known as the canon law, was based on the principles of the Bible and Roman law. During this period, scholars began to analyze the concepts and principles of law more systematically, laying the foundations of the modern jurisprudence. In the 6th and 17th century, the natural law theory became popular among jurists. According to this theory, the law is based on the moral principles that are inherent in human nature. The natural law theory was developed by philosophers such as Thomas Aquinas, Hugo Grotius, and John Locke. They argued that the law should be used to promote justice, fairness, and the common good. That is law as it ought to be. And I will have a brief discussion on the issue of natural law separately in this video. In the 18th and the 19th century were a time of great changes in the study of jurisprudence. So you have to note that the 18th and the 19th century, there was a sudden change in the study of jurisprudence. During this period, there was a shift towards a more empirical approach to the study of law. Jurists began to analyze the legal system more systematically and scientifically using methods other disciplines such as sociology, psychology, and anthropology. That is where we see the emergence of sociological jurisprudence and legal realism. In the 20th century, jurisprudence continued to evolve, influenced by social, political, and economic changes. One of the most significant developments was the emergence of legal positivism, which argued that the law is a product of the state and can be studied objectively, that is, law as it is clearly. And we see the manifestation of this positivist approach in the rules of interpretation, that is the literal rule. I'll discuss legal positivism later. Another important development was the rise of the critical legal theories, which questioned, or the rise of the critical legal studies, which questioned the assumptions and the limitations of the traditional legal theory. So I will now then summarize the perspectives in jurisprudence. Several perspectives of jurisprudence have emerged over time, like I have stated, from the natural law to the critical legal studies, the sociological approach, feminism. I will all discuss these perspectives. These perspectives, reflect different approaches to the study of law and have contributed to the development of the legal systems globally. I'll start by the most popular and the well-known, that is the natural law perspective. The natural law perspective is based on the belief that the law is derived from moral principles that are inherent in the human nature. According to these perspectives, the law should be used to promote justice, fairness, and common good. Natural law theorists argue that the law should be based on reason and not arbitrary rules or the will of the state. So this is where we see the emergence of what is known as the law, what the law is ought to be. The law is ought to be just. The law is ought to be have common good, not to be arbitrary, as was stated by one of the most well-known natural law theorists, Thomas Aquinas, a Catholic philosopher who argued that the law should be based on natural law, which is derived from the divine revelation, reasons, and human nature. He believed that the law should be used to promote common good, that it should be in harmony with the moral principles. So, a good illustration of the manifestation of natural law in Zimbabwe is the 2022 judgment by the Masvingo High Court judge, senior judge, that is Honorable Justice Mawadze. The High Court judge, Justice Karainashe Mawadze, gave probably Zimbabwe's shortest sentence ever for murder with actual intent when he ordered a convicted person to remain in custody until the rising of the court. So the judgment was just that you are sentenced until the rising of the court. And then this meant that the 17-year-old girl who was convicted was sentenced to a few seconds in custody, since the Justice Mawadze, immediately after the pronouncement of the judgment, rose from the court and left the court. The accused was a free person thereafter. The accused was charged with murder with actual intent after she threw her 2-year-old baby into the Trigui River in Chibi, following persistent harassment and physical abuse by her grandmother and brother, justifying rather the unusual sentence in Zimbabwe. Justice Mawadze said that it was necessary to be lenient with the convict because she was raped by her uncle at the age of 14, had a child at the age of 15, dropped school in Form 1, and was ostracized by her grandmother and brother throughout the period. He added that the girl had no parental support since her father and mother had separated long before she was raped. She was also traumatized because the uncle who raped her is still a free man many years after the crime. Justice Mawadze said it was not difficult for him to give a guilty verdict against the accused, but he had a dilemma in coming up with an appropriate sentence considering this trauma that the convict went through. So this case actually gives us a brief illustration or manifestation of natural law, that the morals of the society should be considered when judges are giving someone a sentence. So what is the law? The law is ought to promote common good. The law is ought to be just. So by serving this girl a shorter sentence, considering her trauma, the trauma which she had faced, the justice justified that it was appropriate for him to give the young girl this sentence. Another example is the emergence of the Boni-Mores test in our law of delict, or in other jurisprudence they will call it tort law. In Zimbabwe it is called the law of delict, where they use the Boni-Mores test, that is the legal convictions of a moral society, why the moral society would think that when one is trying to prove wrongfulness, the boni mores test, the legal convictions of the society are the ones which are used to determine whether or not a person actually acted in wrongfulness or not. A lesson from South Africa would be drawn from the famous case of Ace versus Makwanyane, in which Justice Dikoto emphasized the constitutional right to life. He argued that the imposition of the death penalty called for a value judgment that could be influenced by one's moral attitude and feelings. He acknowledged, however, that the court's experience and training warned against the trap of subjectivity. You can also see the issues to deal with civil disobedience, the Mandela case, the famous Mandela case in South Africa, where the court used the moral test to determine whether Mandela was still fit and proper, as Mandela had argued that he entered into civil disobedience because he wanted to fight for a law which was unjust, because the law is ought to be just. So then I will now move on to the legal positivism perspective. Legal positivism is based on the idea that the law is a product of the state and can be studied objectively. According to this perspective, the law is not necessarily based on moral principles or natural law, but rather the will of the sovereign state. Legal positivists argue that the law is defined by what is written in the codes and statute rather than the moral or religious principles. This is where we see the emergence of what we call the literal rule, which was mostly set out in the locus classicus case of Ara versus Venter, which states that the word in the statute must be followed unless so leads to a glaring absurdity, meaning that if the words in the statute are followed, it will manifest legal positivism, the law as it is, not the law as it ought to be. One of the most influential legal positivists was Kelsen, that is Hans Kelsen, an Australian jurist who argued that the law is a hierarchy of norms with a basic norm at the top to establish constitutional framework for the legal system. Kelsen believed that the law should be studied objectively without referencing to moral or political values. Also, you can also see John Austin and the famous Professor Hart. So a good example of the application of legal positivism in Zimbabwe is seen by the Supreme Court judgment in the case of Romeo Zibani and Judicial Service Commission, and another in which a fourth-year university student at the University of Zimbabwe, law student, filed an agent chamber application in the High Court. The Caleb Macheche, in his article, provides that the Supreme Court deferred with the High Court and premised its decision on the law as it is and not the law as it ought to be, a jurisprudential principle that finds its manifestation in legal positivism. Then I'll now move on to the other perspective, that is the critical legal studies perspective. Critical legal studies perspective emerged in the 1970s, which, like I said earlier, questioned the traditional legal theories, assumptions, and limitations. So critical legal scholars argue that the law is not objectively or neutral, but rather influenced by social, economic, and political factors. So you can also see one of the most influential critical legal scholars was Roberto Unga, a Brazilian philosopher, who in his book entitled The Critical Legal Studies Movement argued that the law should be used to promote social justice and human flourishing. So I will give an example of how the manifestation of critical legal studies actually arises more specifically in Zimbabwe. As I have said earlier, that my lecturer is Mr. Nkosana Maphosa. And Nkosana Maphosa, in Selected Aspects, that is the second edition, when discussing the concept of legal transplantation with regards to foreign law, as required by Section 46 of the 2013 Constitution of Zimbabwe, provides that foreign law may very well speak directly or indirectly in the legal issues in Zimbabwe, but it is usually unfit and should therefore be adapted to marry the local socio-economic, cultural, and political context. So this means that the law, even if it is being adapted or there is legal transplantation, the law should then operate to fit in the socio-economic, cultural, and political perspectives as per Mr. Nkosana Maphosa. This view is more similar to the view of the critical legal studies movement. Now I will talk about the feminist perspective. So the feminist jurisprudence is a perspective that emerged in the 1970s as well, which focuses on the role of gender and discrimination in the law. Feminist jurists argue that the law has historically been biased against women and the legal systems have perpetrated patriarchal norms and values. Feminist legal scholars like Catherine McKinnon and Patricia Wills have explored a range of issues including reproductive rights, domestic violence, sexual harassment, and gender pay gap. They have also argued the inclusion of feminist perspectives in the legal system and the use of the law to promote gender equality and social justice. So I'll just try on to give a brief illustration of this feminist approach in Zimbabwe's jurisdiction. So in Zimbabwe's jurisdiction, we have the new constitution that emerged in 2013, that is the 2013 constitution. And in terms of Section 56, the constitution calls for what we call substantive equality. And substantive equality mostly targets the vulnerable groups, and women are part of the vulnerable groups as per Section 83 of the Constitution of Zimbabwe. So this means that the law is now moving towards the promotion of justice or gender equality and social justice between men and women. We can also see the emergence of the Domestic Violence Act in Zimbabwe and the emergence of sexual or reproductive rights in Zimbabwe, like the issue to deal with the Termination of Pregnancy Act. And a lesson from South Africa can be drawn from the case of Bay and another versus the magistrate Kaelicha and another, where Langa DCJ, as he then was, took a stance of feminist jurisprudence when he developed the primogeniture principle under the law of succession of South Africa. So another perspective that I'm going to deal with is the Marxist perspective. The Marxist perspective is a theoretical framework that views the law as a product of social relations and economic forces. It argues that the law is not neutral but serves the interest of the ruling classes, and that the legal norms and institutions reflect and reinforce the dominant ideology of the ruling class. That is what the Marxists also talk about. So I will now give an example of the manifestation of the Marxist approach in Zimbabwe's jurisdiction, or comparing it with the South African jurisdiction. And the emphasis is mine. If we go to, or we look at Section 74 of the Zimbabwean Constitution, it provides for a right to freedom from arbitrary eviction without a justifiable cause and a court order. But the Zimbabwean Constitution, unlike the South African Constitution, does not provide for the socio-economic right to housing. So what is there in terms of Section 74 is that the Constitution itself already assumes that one has a house. It provides that your house should not be arbitrarily evicted, or your house should not be demolished. That it means that it assumes that you already have a house, but it does not actually focus on whether the person does not have a house or not. This itself is a manifestation of Marxist, because the people who drafted the constitution did not consider those people who do not have the monetary value to buy houses and just being granted like South Africa. The South African constitution itself provides for the right to housing. So another thing that I will also discuss is the Labor Act itself, in the most famous case of Zimbabwe, that is the Utoni Nyamande and others versus Zuba Petroleum, which the case has been described to have the case which served the interest of the ruling classes in Zimbabwe, that is those employers, not considering even the best interest of those people who were employed with children, meaning that the law only protects the employer as compared to the employee. Then after that, I will just give a brief touch on sociological jurisprudence as one of the last perspectives. There are various perspectives like realism, I have not discussed it, the critical race theory, law and economic development approaches, legal pluralism, I have not discussed that. I have selected one of the most important aspects or the most important perspectives in jurisprudence. Social jurisprudence is a branch of legal theory that seeks to understand the relationship between the law and the society. It is concerned with how socioeconomic or political factors influence the development, interpretation, and enforcement of law. So, sociological jurisprudence deals with the fact that the law and the society are something which have a strong relationship. The application of sociological jurisprudence can be seen in various areas, including criminal justice, family law, labor law, and environmental law. For example, sociological jurisprudence can help explain why groups of disproportionalities impacted the criminal justice, why certain employment practices may perpetrate inequality, and how environmental regulations can affect communities differently based on socio-economic status. So the famous Makwanyane case, like the S versus Makwanyane case, like I have cited it earlier on the natural law, also plays a part in sociological jurisprudence, where Madala J also took the principle of Ubuntu as a source to define constitutional values. Ubuntu is an African word which means humanness, umuntu ngumuntu ngabantu, meaning that at the stance of considering Ubuntu to define the constitutional values is something which shows a strong relationship between the law and the society. So I have touched on the perspectives of jurisprudence, the different perspectives, and I will now give a general overview of exactly what jurisprudence is about after discussing these instances, these perspectives. Then after that, I will then move on to the case of the Spelunkian explorers. Then at the end, I will then give a brief conclusion of this video. So basically, I will now move on to the general overview of jurisprudence. As noted earlier, jurisprudence seeks to understand the nature, the purpose, and the effects of law. It aims to develop the general principles of law that can be applied in different legal systems and to explore the philosophical and theoretical foundations of law. Jurisprudence also seeks to examine the role of law in the society and to understand how legal systems can be used to promote social justice and social good. One of the fundamental questions that jurisprudence seeks to answer is, what is law? The law can be defined in different ways depending on the perspective of the person defining it. Analytical jurists, for example, define the law as a set of rules that are enforceable by the state and backed by sanctions. Natural law theorists, on the other hand, define the law as a set of principles that are grounded on the natural law and morality. Another question that jurisprudence seeks to answer is, what is the purpose of law? Different legal systems have different goals depending on the values and traditions of the society in which they exist. Some legal systems focus on maintaining order and stabilities, while others prioritize individual rights and liberties. Jurisprudence seeks to understand the goal of the different legal systems and to evaluate them based on the effectiveness in achieving these goals. Jurisprudence also explores the relationship between law and morality. Some legal systems are based on moral principles, which others are more utilitarian in nature. Jurisprudence seeks to understand how the law and the morality interact and how they can be reconciled when there is a conflict between them. It examines how legal systems can be used to promote moral values such as justice and equal treatment. Another important area of interest in jurisprudence is legal reasoning. How do judges and other legal authorities arrive at their decision? What factors do they consider and how do they weigh them? Analytical jurists seek to understand the logic and the method of legal reasoning and to develop the general principles that can be applied in different legal systems. Jurisprudence also examines the role of law in promoting social justice and public good. Legal systems can be used to address social inequality and to promote the welfare of the community. Jurisprudence seeks to identify how legal systems can be designed to achieve these goals and to evaluate the effectiveness of the different legal interventions. So I will now move on to the case of the Spelunkian explorers. The reason why I'm referring to this case, like I have stated earlier, is that the case gives us a general overview of what exactly jurisprudence is all about, like I was summarizing what jurisprudence is all about and some of the principles I have stated about. The case of the Spelunkian explorers is a fictitious case created by Lon Fuller in the case of the Spelunkian explorers 1949-62 brackets for Harvard Law Review 616. The case takes place in a fictitious Commonwealth of Newgalt, and Fuller's article contains 5 judicial opinions that explore the facts from different legal perspectives. So I'll give the brief factual background of the case. A group of cavemen, explorers, spelunkers, are trapped by a landslide. Approaching starvation, they make a radio contact with the rescue team. Engineers on the rescue team estimate that the rescue will take a further 10 days. After describing their situation to the physician, they are told that they are unlikely to survive another 10 days without food. The explorers asked the physician whether they would survive if they killed and ate one of their numbers. The physician advised reluctantly that they would. When asked if they ought to hold a lottery to determine who would be killed and ate, no one on the rescue team is willing to advise. The radio is turned off, and later a lottery is held. The loser is killed and eaten, and when they are rescued, they are prosecuted for murder, for which the Commonwealth of Newgalt, a guilty verdict, carries a mandatory sentence of capital punishment. I will now move on to the opinion of the judges. So the opinion of the judges itself gives us what the jurisprudential terrain is all about. Faced with this dilemma, each of the justices come with different conclusions. The Chief Justice, who was True Mpheni, agrees that the law has been violated and that judges, both at trial and on appeal, have no choice but to uphold the conviction. He says that the statute permits no exception applicable to this case. However, our sympathies may incline to us to make allowances for a tragic situation in which these men were found themselves. But although the Chief Justice agreed that the law required a sentence of death, he also believed that It was open to the justices to communicate with the chief executive of the governor's court to recommend that the exercise of his power of clemency to pardon the defendants despite their guilt. Chief Justice Strumeni preferred a result that would close outcome in the Dudley versus Stephens case, the Ara versus Dudley case itself, but with an added flip of the Chief Justice expressly arguing that the court itself recommended this course of action to the governor. Justice Foster, whom his jurisprudence will recognize as pretty close as to Fuller himself, like Fuller is the one, like I said, Fuller as I stated him, offered two arguments for acquittal, arguments that went to the literal application of the statute. The first argument was that the statute was designed to be applied with normal function of the society, and that the existence of such a society was necessary in the condition of the application of law. But because of this situation arose in some other closer to the state of nature and was thus analytically, if not temporarily, pre-legal, the law of new dates simply did not apply, and therefore the statute did not apply. He stated that in his way. When a situation arises in the coexistence of men becomes impossible, then a condition that underlies all of our precedents and statutes have ceased to exist. When that condition disappears, then, in my opinion, that is the force of our positive law disappears. So what Justice Foster was actually talking about is the maxim, some will call it the Sesante maxim, which talks that if the reason of the law falls away, the law also falls away. The case of S versus Moji greatly illustrates it. So, what Justice Foster, another argument which was set out by Justice Foster, was more of like a fuller tone. He states that a man may break the letter of the law without breaking the law itself. Every proposition of positive law, whether contained in the statute or judicial precedent, is not interpreted reasonably in light of its evident purpose. So what Foster was actually trying to articulate was the purpose of the law. He was saying that neither the purpose of this law nor the purpose of the law in general would be served by the literal application of the statute in this situation. That was what Justice Foster was talking about. Then the third judge, that is Justice Tating, expressed sympathy with Justice Foster's position about purposive interpretation, but not with the Foster state of nature argument, but was troubled in applying the position in light of the many multiple purposes of criminal law. Like criminal law has multiple purposes. So what Justice Tating actually stated was that absurdity of directing that these men be put to death when their lives have been saved by the cost of their lives of 10 heroic women. As a result, he found himself undecided and unanguished. This is what Justice Tating. Also, he wished that the defendants had not been indicted in the first place. He noted that it was too late in the day for this option. For himself, therefore, the moral legal dilemma was unavoidable. Unable to reach the decision, he felt compelled with the regret to withdraw from the decision of the case. So what Justice Tating actually did within the 5 judges was actually to just withdraw the decision from the case. Not such doubts plowed in Justice Keane. For him, the law was clear, and for him, the role of the judge was limited in applying the law. Question of policy, executive clemency, and morality were others. He stated that the difficulties in whatever tortured form they may present themselves all trace back to the single source, and that is failure to distinguish the legal from the moral aspects of this case. I respect the obligations of an office that requires me to put my predictions out of my mind when I come to interpret and apply the law of the Commonwealth. Justice Keane thus had no hesitation in saying simply that the conviction should be upheld because this was a more of a positivist. The literal rule just say the statute is clear and we as judges were not allowed to apply our moral mind, then therefore these people are guilty. For Handy, simple common sense coupled with consultation for the public opinion could be a matter at hand, was sufficient to resolve the issue, and without all the legalistic trapping some troubled his colleagues. So you say that the law, this case should be deducted by just common sense, nothing more, nothing less. We just use our common sense to determine the matter. So this is just a brief summary of what happened in the case of the Spalangian explorers, the opinion of the judges. So the judges gave a brief overview. The other judges were saying the purposive approach, other was using the principle of law as it is, that the judges should not apply their moral feelings, their moral affiliations to the case. They just have to interpret the law as it is. The other was saying the society, the relationship with the society. The case of the Spalangian explorers actually now gives you a brief overview of the perspectives that I have talked about, their application, when the judge interprets the law, where the judge sees the law. So judges see the law differently. Judges see the law from different perspectives. So in conclusion, jurisprudence is essential in the field of the study that has contributed to the development of legal systems globally. It seeks to understand the nature of the law, its relationship with the society, and how it can be used to guide human behavior. Over time, jurisprudence has evolved, like I have stated, and has been influenced by social, political, and economic changes, and even religious changes if you look at the orthodox principle. There are several perspectives of jurisprudence reflecting different approaches to the study of law and its related theories. The natural law, the feminist, the critical legal studies, sociological jurisprudence, law and economic development, the Marxist perspective, just to give a short list. All these perspectives give a brief synopsis or a synopsis of how one would look at the jurisprudential terrain. Jurisprudence continues to play a vital role in shaping the legal system worldwide, and legal practitioners need to understand its key principles and concepts. As the world changes, jurisprudence will continue to evolve to adapt the new social and political and economic realities. Thank you.